Welcome to Post-Conviction Advocacy for Survivors of Trafficking and Immigration, co-sponsored by the ABA Commission on Domestic and Sexual Violence and the ABA Center for Professional Development. Moderating the program today is Bonnie Carlson. Bonnie is an attorney at the ABA Commission on Domestic and Sexual Violence in Washington, D.C. Bonnie, you may proceed with your program.
Thank you. I'd like to welcome everyone to today's webinar. Joining me on the program today is Kate Mogulescu, who is the Survivor Reentry Project's lead attorney and the director of the Criminal Defense Advocacy Clinic at Brooklyn Law School. We also have Ryan Muennich, a staff attorney at the Immigrant Defense Project. And finally, we have Natalie Nanasi, the director of the Judge Elmo B. Hunter Legal Center for Victims of Crimes Against Women at the SMU Dedman School of Law. Kate, I will turn it over to you.
Thank you so much, Bonnie. Welcome, everyone. This webinar builds on our 4 prior webinars in the Survivor Reentry Project webinar series, where we've looked at what human trafficking is, how victims of human trafficking come into the criminal legal system, and what the impact of their involvement in the criminal legal system is on their ability to obtain safety, independence, and stability. We've looked at trauma and best practices of working with people who have experienced trauma. And today we're going to focus on non-citizen victims of human trafficking and look at which legal systems they come into contact with and what system responses practitioners working with non-citizen victims can expect, anticipate, and work around. In particular, we're going to be looking at understanding clients' immigration status and specific risks or relief that they might face. For some of you, this might be a review. Some of you might be hearing this for the first time. We're going to understand and go through what affirmative immigration remedies exist for non-citizen victims of human trafficking. Then we're going to look at victims who have had criminal legal system involvement and have arrest and conviction histories that may impact their immigration status. We're going to think through how these systems, the interplay between these systems, and what are best practices for lawyers representing non-citizen survivors of trafficking in post-conviction cases. For the initial part of the program, Natalie is going to be taking us through the overview and a look at some of the affirmative humanitarian remedies for victims. Oh, but I forgot to do one thing first. Sorry, everybody. Before we begin, I just want to actually see who is joining us for today's webinar. And so we're going to very quickly ask you to take a poll. Let us know, those of you who are joining us, if you are a public defender, a criminal defense attorney in another context or capacity, a civil legal services attorney, a pro bono attorney, a social worker, prosecutor, a judge, or another member of law enforcement. Once again, if you can indicate if you are a public defender, another type of criminal defense attorney, a civil legal services attorney, pro bono attorney, a social worker, prosecutor, judge, or other member of law enforcement. Okay, it seems like we have a diverse group of attorneys both within the civil and criminal sector with us, and a few social workers as well. So thank you all for joining us today. And with that, I'm going to turn it over to Natalie.
All right, thank you, Kate, and thank you, everybody, for being here today. As Kate mentioned, my role here today is to walk you through the immigration system, and we will begin by just thinking at the absolute basic level of what are different immigration statuses that people might have when they're coming to you. You'll see here on the slide a variety of immigration statuses essentially sorted in descending order by security of status. So U.S. citizens obviously are the most securely here in the United States, followed by green card holders, then followed by a category of people called non-immigrants, which is a bit of a term of art. It doesn't mean that they are not immigrants. They're just distinguished from green card holders. This non-immigrant category are going to be the visa holders that we spend a lot of time talking about today. And then lastly, undocumented individuals, people that don't have any immigration status here in the U.S. if you have been paying any attention to the news lately, if you've opened a newspaper, opened the internet, you're probably aware that this is a challenging time for an immigrant population. And so I just wanted to put out there that if you're on this webinar, you're probably aware of some of the traditional barriers that survivors have to accessing services. I know that one of the webinars in this series has been about trauma. The immigrant population faces additional barriers, things like language access, and then now thinking about heightened enforcement and in some ways arbitrary enforcement in immigrant populations. We're no longer only going after people that we deem unsuitable as we did before. We no longer have the enforcement priorities that we had. And so everybody feels a lot more targeted in the immigrant community, and I think we need to be aware of that fear and have a heightened sensitivity to immigrant victims that we're encountering. So with that very, very brief introduction into the immigration system, what I'm going to do today is walk through 3 different forms of immigration relief that might be eligible to survivors of human trafficking. The T visa, the U visa, and then very briefly at the end to talk about eligibility for asylum in the United States. So let's start off with the T visa. These are the factors that you need to prove in order to get a T visa. You have to demonstrate that the individual is a victim of human trafficking, is physically present in the United States on account of that trafficking, that they've complied with any reasonable requests for assistance in the investigation or prosecution of that trafficking, and lastly, that they would suffer extreme hardship if they were removed from the United States. And I want to spend some time breaking down some of those elements. So the definition of trafficking is probably one that you are very familiar with because the immigration, or the definition of trafficking for immigration purposes tracks definitions that we see in federal law and probably most state laws as well. So we've got sex trafficking, which is the recruitment, harboring, transportation, provision, obtaining, patronizing, or soliciting of a person for the purpose of a commercial sex act. And again, that is sex in exchange for money. And where that commercial sex act was induced by force, fraud, or coercion. And if the individual is under 18 years old, so if we're talking about a minor, we don't need to show that force, fraud, or coercion piece. We just assume that if it is a minor having sex in exchange for money, that is a de facto trafficking situation. We also have labor trafficking, which is very similar to the sex trafficking definition. We've got the recruitment, harboring, transportation, provision, obtaining of a person, but this time for labor or services. Again, we see that force, fraud, or coercion, but here the purpose is for involuntary servitude, peonage, debt bondage, or slavery. So sometimes I think it's helpful to look at these definitions not so much in a jumble of words. So we like to break it down into 3 different sections. One is you need to have an action, right? So you see all those actions listed there in the left-hand column. There's a means, that force, fraud, or coercion. And remember, you don't need to show that force, fraud, or coercion if it is a sex trafficking victim who is a minor. And then you need a purpose, right? Either the forced labor or a commercial sex act. So how do we know if somebody is a victim? We see that phrase force, fraud, or coercion a lot, and I think it's helpful, especially for those of you that may not have a lot of experience working with survivors of trafficking, to break down exactly what those terms mean. So you'll see here a list of several different situations that might happen. I like to think of these as maybe questions that you might want to ask somebody or facts that you might want to look for in a particular case, right? So asking if somebody had control of their documents, what their working conditions were like, whether they were being paid if they were working, what their living conditions were like, were there any threats, were they able to come and go? And so importantly here is that you'll see encompassed in a lot of these bullet points that you see in front of you is that forced fraud and coercion can take the form of the traditional chains that we might think of when we think of trafficking, right? Somebody is literally held in a place, locked into a room, chained to a bed, unable to leave a situation and forced into either sex work or another kind of labor. But you may often see those invisible chains, right, where the door is wide open, but that person doesn't have control of their identity documents, or they're told that they can absolutely walk out the door, but the trafficker will harm a family member back in their home country. And so all of these things, it's important to note them just to see that there are different ways that the trafficking, that forced fraud or coercion can manifest, and it's important to ask a lot of questions along the lines of some of the things that you see here and more to determine whether or not somebody is a victim. So moving on, a critical piece of an application for a T visa is assistance to law enforcement. So the trafficking must be reported to a law enforcement agency, and we typically see the reports happening either typically to federal law enforcement, to the Department of Justice, to the FBI. I have ICE on here, but for some of the reasons that I articulated earlier, you may be wary of reporting to an immigration enforcement agency, but that if there's a relationship that you have with somebody in your particular community, that's an option as well. And of course, you can also report trafficking to local law enforcement, to state law enforcement. The victim, in order to receive a T visa, is going to be required to cooperate with the law enforcement agency that they reported to, but there are a couple of exceptions. So again, we see another exception for minors. So if somebody is under the age of 18, they don't have to provide that assistance to law enforcement. And also if you can demonstrate that some sort of either physical or psychological trauma would prevent that survivor from cooperating, you are exempt from this requirement. And I just want to note here, it's very important to not conflate assistance to law enforcement with a successful prosecution or investigation. As many of us know, prosecutions and convictions in this area are rare, and so the T visa does not require that the trafficker be arrested, doesn't require that the trafficker be tried or convicted. It just requires the individual to assist law enforcement in their investigation or their prosecution. So moving on, the last requirement for the T visa is that the person be subjected to some sort of extreme hardship if they were removed from the United States. So typically, if somebody is a survivor of trafficking, this requirement is not going to be hard to meet given the experience that they had in the United States. But some of the things that we're looking at is thinking about some services that they're receiving here in the United States, mental health services, medical services, something like that they wouldn't be able to get back in their home country. We think a lot about retaliation, either that the trafficker would retaliate against them if they were able to access them in their home country, or they would be re-victimized, potentially vulnerable to re-trafficking. And that's thinking not only about the trafficker, but also about whether they would be at risk from the government in their home country, or whether they would sometimes, you'll see that the trafficking survivors, especially in the area of sex trafficking, are concerned about the treatment that they'll get, for example, from their families. If they're seen as unclean or having transgressed some sort of cultural norms due to the trafficking that they experience here in the home country. So if you can demonstrate any of those factors, and of course if there's an ongoing investigation or prosecution and their removal would result in them not being able to participate, that's another avenue to establish one of those extreme hardship factors. I do want to note that economic harm or lack of economic opportunity is not going to be sufficient to demonstrate this extreme hardship. But again, given the situations that people find themselves in after they've been trafficked here in the United States, this extreme hardship prong tends to be not too difficult to prove. So after, ideally, we hope that somebody files this application for the T visa and receives it. This is what the slide that you see in front of you is what they are going to get with their T visa. So they will get a legal status, which is that non-immigrant visa that we talked about at the beginning, and work authorization that's going to be valid for 4 years. They're going to be eligible for actually quite a generous package of public benefits, and they will be able to petition for any derivatives or family members. Either those are family members who are either already here in the United States or family members that that are in the home country that they would like to join them here in the U.S. So if there's an applicant who's under the age of 21, they can petition for their spouse, their children, their parents, and any unmarried siblings who are under the age of 18. And for applicants who are 21 years or older, just their spouse and their children. And importantly, the T visa allows for somebody to what we call adjust their status to a lawful permanent resident status, or basically to get their green card, to again move from that non-immigrant category into an immigrant category after they've had that visa for 3 years, or if there's been an investigation or prosecution at the conclusion of either that investigation or the prosecution in the criminal case. So that is the T visa. I'm going to now move into talking about the next visa, which is the U visa. So the U visa and the T visa actually have a fair amount in common. They were created by the same piece of legislation coming up on 20 years ago now. And the U visa was created because of an understanding that immigrants are uniquely vulnerable to being victimized by crime, but also uniquely fearful of engaging with law enforcement. That was true 20 years ago, and it's even more true now. So what the U visa is intended to do is to remove one of the barriers that people might have, which is fear about their immigration status, and allow them to feel more comfortable coming forward, reporting crimes to law enforcement, which would in turn make them safer, but then also help authorities identify, apprehend, and prosecute perpetrators of crime. The U visa eligibility factors are in this slide that you see in front of you. Again, we've got 4 of them. You have to demonstrate in order to get the visa that the applicant is a victim of a qualifying crime in the United States, that the victim possesses information about that crime and is going to be helpful to law enforcement. Again, we see an element here of cooperating with law enforcement agencies. And then lastly, that they suffered substantial physical or mental abuse as a result of their victimization. So I'm going to go through a couple of these in a little bit more detail just to put some meat on these bones. What you'll see here is a list of qualifying criminal activities. These are the crimes that would make somebody U visa eligible. The first one you'll see right there at the top is trafficking. But then many of the other crimes on this list are crimes that are likely going to be attendant to trafficking. For example, rape, sexual assault, kidnapping, torture, felonious assault. Any of these crimes would make somebody U visa eligible and would also likely be encompassed in a situation of human trafficking. The 2 other important things to note about this list of qualifying criminal activities is that you see at the top the language of the statute says that it has to be one of these crimes or any similar activity. So what that means, for example, is that if your state doesn't have a felonious assault a charge in the criminal code, that the wording is a little bit different, right? Or if the kidnapping statute looks a little bit different, it doesn't matter. What I want you to take away is that you don't need to worry too much about exactly what the language of the criminal code says, as long as it is somewhere in the neighborhood of one of these crimes that you see here on this slide. The other is, as you'll see asterisk on the bottom, is that attempt, conspiracy, or solicitation to commit any of these crimes will also make somebody eligible for the U visa. So, for example, they wouldn't have to necessarily have gone through with the murder in order to make somebody U visa eligible, right? You've got a victim of an attempted murder who can file an application for a U visa. So once we demonstrate that somebody is a victim of crime, the next thing that we have to do is show that they possess information about that crime and that they have been helpful to law enforcement in the investigation or prosecution of that crime. The statute is actually quite broad when it thinks about helpfulness, so it contemplates somebody who was helpful in the past, somebody who is currently being helpful to law enforcement, or somebody who might be helpful to law enforcement in the future. And again, much like the T visa, what we're thinking about here is helpfulness and not necessarily a particular outcome in an investigation or the prosecution of a case. There is an ongoing responsibility to cooperate, and you'll see, you'll notice here that there are, with the U visa, we don't see the same exceptions that we have for the T visa in terms of trauma, in terms of physical inability or minority. There really is this responsibility to cooperate throughout the life of a criminal case, so much so that even after the U visa is filed and the individual ceases to cooperate with law enforcement, that the certification form that we'll talk about in just a moment that law enforcement signs to certify an applicant's helpfulness can be withdrawn. So it's just important for victims to understand that in order to get this U visa, they really have to stick with the criminal case and to be available to law enforcement whenever they're requested to help. And then just to note quickly here in terms of helpfulness, the one, I wouldn't even call it an exception, but the one kind of small caveat is that if the victim is either incompetent, incapacitated, or under 16, a parent or guardian can do the cooperating on their behalf. So again, that doesn't mean they don't have to cooperate, it just means somebody else can do it for them in those limited circumstances. So I mentioned before the law enforcement certification, which is an absolutely critical piece of any U visa application. If that certification form is not submitted, that U visa application will not even make it out of the mailroom at the Immigration Service. So it's incredibly important that that's submitted. And what that means is that you have to have one of these certifying agencies that you see in front of you sign off on this piece of paper. It's the USCIS Form I-918 Supplement B. You can find it with a quick Google search. And one of these agencies is going to have to certify that the victim was in fact cooperative in the investigation or the prosecution. So typically who you see signing these certification forms tend to be police or prosecutors. But I will say that this tends to be really jurisdiction specific, right? So there are some jurisdictions in which there are very established processes and procedures for police departments and prosecutors' offices to sign these law enforcement certification forms for U visa applicants. And there may be other jurisdictions where either the law enforcement entity is unaware of the U visa, doesn't have a policy in place, or where they may be resistant to getting involved in an immigration matter or have blanket policies where they're just not going to sign these certification forms. So in that case, a lot of us in the immigration world have done a lot of work and a lot of advocacy in terms of having conversations with our law enforcement agencies to talk to them about why it's actually in their interest to sign off on these forms. There are a lot of resources out there, so I definitely encourage you, if you're working with a recalcitrant agency or an agency that's either has questions about what these forms are or is reluctant to sign them, there are a lot of resources out there to help you figure out how to have productive conversations with your law enforcement agencies. But that being said, if you're kind of getting nowhere with your police or your prosecutors, there are other members of law enforcement who can sign off on these certification forms. So remember always that judges can sign off on these certification forms, and a lot of other different agencies that actually have what's called criminal investigative jurisdiction. So if you're working on a child abuse case, Child Protective Services may be able to sign off on your certification form. If it's a crime that took place, for example, let's say a sexual assault that happened in the workplace, or a trafficking incident that happened in the workplace, the Department of Labor, the EEOC, all of those agencies actually are able to sign off on these certification forms. So the lesson is really to think broadly and to be creative about who you are asking to verify your client's helpfulness in order for them to be able to do an application for a U visa. So assuming, again, you get the certification form signed, you send in the U visa application, these are the benefits that will accrue to somebody with a valid U visa. Much like the T, you see valid legal status and work authorization for 4 years. We've got the same derivatives or family members who can be included on that petition. And again, much like the T visa, after 3 years, that person can file an application for their green card. So both of these visas we see are a path to regularizing an immigration status for the long term. So I've talked a lot in 20 minutes about two visas, and I know I've thrown a lot of information at you. So what you see here is a chart that walks you through the different visas, what's the same, what's different. Because what you may be thinking at this point is, okay, I have somebody sitting here in my office, they're a victim of trafficking. Which visa is right for them? Right? Which one of them can I pursue? Which one should I pursue? And again, what I should say actually at the outset is that if you're not an immigration attorney, I don't know if when we did the poll, how many of you within that civil legal services are immigration attorneys, but if you're not, of course the most important thing to do is to get the victim, to get the survivor to an experienced immigration attorney that can help you assess eligibility. But just so you all have some of this information at hand if you ever need it. So in terms of eligibility with the T visa, again, some of this is review. For the T visa, you need to, the person needs to be a victim of a severe form of trafficking. For the U visa, it's just the victim of a qualifying criminal activity, which could be trafficking but could be one of several other crimes. Both require cooperation with law enforcement, with the T visa having a larger exception for people who are unable because of trauma or because of minority to cooperate with law enforcement. The T visa has this extreme hardship criteria, which is an addition, and the U visa doesn't have extreme hardship, but you do have to demonstrate that the person suffered substantial abuse as a result of having been a victim of a crime. We didn't talk about this too much, but both visas actually have something called a waiver of inadmissibility that is attached to them, which is if somebody has prior immigration history or prior criminal history, you can request for those things for the Immigration Service to waive those things that would otherwise make them inadmissible to the United States. For the T visa, the waiver is available if that unlawful entry, for example, or that prior crime is related to the trafficking that they suffered. The U visa waiver is actually much broader. All you have to show is that it is in the national or public interest to waive that inadmissibility ground. So that is oftentimes a really important factor in deciding whether or not you want to apply for a U visa or a T visa. If somebody has something in their past, again, some kind of immigration history or some sort of criminal history, it may be easier to waive those issues with the U visa. Moving on, you'll see both visas are valid for 4 years. Both visas allow for family members to be included. Another significant difference comes when you start thinking about public benefits. The T visa, as I mentioned, has a relatively generous package of public benefits that are available, which can often be incredibly important, sometimes even life-saving for survivors. And when I mention public benefits, I mean things like access to medical care, access to mental health services, even cash benefits that allow them to obtain housing. All of that's going to be available for the T visa, whereas with the U visa, the benefits are very, very limited. I would say almost non-existent at this point. Both visas allow for the individual to eventually file for their green card, which so it's the same for both. And then last but not least, and this is just another really important factor that I will flag for you when trying to make a decision of whether a T visa or a U visa is right for a client. Both of them have caps, meaning that within the statute it says that the Immigration Service can only issue 5,000 T visas every year and 10,000 U visas every year. The T visa cap has never been reached, which means that if you apply for a T visa, after several months adjudication time, that visa can be issued. The U visa cap has been reached for many, many years in a row, and the visa issuance is now incredibly backlogged. And what I mean by incredibly backlogged is something in the order of, I think it's looking about 8 years right now, which is an amazingly long amount of time. And so it may be close to a decade before somebody gets the U visa after they have filed for it. Within that time, after a few years, they're likely be eligible for work authorization, but they still will not have legal status during the duration of that time that they're waiting for the visa to be issued. So that's an incredibly important thing to think about because the T visa is going to be a much faster way to get somebody legal status. Okay, so last but not least, as promised, I'm going to just spend a few minutes talking about eligibility for asylum for survivors of trafficking. So in order to be eligible for asylum in the U.S., an individual has to meet the definition of a refugee, which you see on the slide in front of you. So a refugee is any person who is outside of their home country, who is unable or unwilling to return to that country because they've been persecuted in the past or they fear persecution in the future on account of their race, their religion, their nationality, their membership in a particular social group, or their political opinion. So I want to break down this definition for you, again with the caveat that this is an incredibly dense and challenging area of the law, and my goal here today is just to give you a very, very broad overview just so that you've got some sense of who might be eligible for asylum, enough that you can flag that person and refer them to an immigration attorney to do a full assessment of their case. So if you're looking at somebody who you think might be eligible for asylum based on the trafficking that they suffered here in the United States, here's a few things you want to look out for. One, we're going to have to demonstrate in that application for asylum that that person faced persecution in the past. And persecution is a term of art, but really you can understand it as a significant harm, right? We're not talking about just some minor issues that they were having. Persecution really is something that tends to be quite serious. We need to show either that they face that persecution in the past and or that they have a well-founded fear of being persecuted in their home country in the future. And that well-founded fear is going to be a fear that that is both subjective and objective. So you have to demonstrate that they are actually afraid, but also that that fear is reasonable given the facts of the case and the conditions in their home country, the things that are going on in that country on the ground what's really happening there. The next two bullet points are probably the most important. So it's not enough that somebody is fearful and fears persecution, but that persecution can't just be generalized harm to that person. The harm has to be perpetrated on account of, that's that nexus piece, one of 5 of the statutory grounds. And I'm going to go back in the slide here, try my little highlighting tool, and these are the 5 grounds that we're talking about here at the end. I apologize, I'm having a hard time drawing a straight line, but you can see. So we have to show that they're being persecuted on account of their race, their religion, their nationality, their political opinion, and importantly, their membership in a particular social group, which is where you see a lot of gender-based claims falling. So many of you may have seen that about a month ago, the Attorney General certified a case to himself dealing with domestic violence-based asylum and issued a decision that very severely limited eligibility for asylum for survivors of domestic violence, survivors of gang-based violence. And really in that case, he cast a lot of doubt on what exactly is this particular social group what is the legal definition of that? What does somebody have to show to be part of a particular social group? Thinking about trafficking, actually somebody who is a victim of trafficking because they are a single woman, for example, without family protection. Something like that may have been a social group in the past. I think given the Attorney General's decision, a lot of those things are kind of up in the air. So what you might want to what attorneys might want to be thinking about in these cases is thinking about the root causes of why somebody was subjected to trafficking in the first place, right? So if, for example, they are a minority racial group in their home country and they're targeted for that reason, it makes them vulnerable to being trafficked here in the United States, and it would again make them vulnerable if they were returned to their home country. That might be a basis for asylum that brings us out of that particular social group and into one of the now safer categories of race, perhaps religion, nationality, something like that. So again, I know that it's incredibly complicated, and this is an ever-evolving immigration situation. But just again to highlight for you that somebody who is unwilling or unable to return to their home country, somebody that articulates to you that they're afraid that they're going to be harmed if they go back to their home country, if they know that their government is not going to be able to protect them, that should raise a flag for you, and that might be somebody that you might want to send to an immigration attorney to see if they might be eligible for asylum, either in addition to thinking about doing a U visa or a T visa application, or for some reason those visas aren't available, asylum might be another alternative to get somebody immigration status. So with that being said, I am going to turn the slides over to Ryan.
And thanks, Natalie. And I'm just going to sort of help us transition here. And this is Kate again, everyone. So Natalie, thank you so much for such a comprehensive but very efficient and succinct view of the different forms of relief that may be available to victims of trafficking. We're now going to attempt to integrate this with really what the focus is of the Survivor Reentry Project, survivors who have criminal records, who have had criminal legal system involvement. And this is an area where we have seen a real proliferation of state law in terms of what relief survivors might be available to survivors for their criminal records, whether it's called vacating convictions, expunging convictions, sealing convictions. The language is very different from state to state, but for purposes of this presentation, we are using the term vacatur One, because New York was the first state to offer survivors of trafficking criminal record relief, and the New York relief allows survivors to actually vacate judgments of conviction entered against them. Ryan's going to talk about what that means in the immigration context, but I'm just trying to explain the language that will be used throughout. I see that we have participants from many different states on the webinar, and so some states follow New York's lead and use the term vacating for criminal record relief for survivors, Wisconsin, New Jersey, for example. Other states have placed the relief within their expungement frameworks, which raises additional questions about how, for non-citizen victims of crime, that relief might be interpreted. So what does this all mean really for non-citizens? We've talked about affirmative remedies, but for non-citizens who have had criminal legal system involvement, who are victims of trafficking, who are then eligible to clear certain things from their criminal records because state law now recognizes that and gives them the opportunity to do so, we understand that non-citizens with criminal histories face very significant and real risks in the immigration system. Criminal histories can render people ineligible for certain forms of relief and can also lead to removal proceedings. So for the next portion of the webinar, we are going to be assuming that the survivor of trafficking that we're working with has had criminal legal system involvement and has been able to utilize relatively new provisions in state law to actually clear some of those things from their criminal record. But what does that mean for them now in the immigration context, both in the affirmative and also defensive context? So for that, we're going to turn it over to Ryan.
Hi, everybody. So yes, just building on what Kate and Natalie talked about, one thing I will add is that Natalie mentioned that there's this waiver process available for those non-immigrant statuses, and that could potentially waive some of this criminal legal contact convictions that you may have problems with. But as anecdotally, lately, the agency has beginning to scrutinize criminal histories more and more. So the actual state processes to vacate these convictions or expunge or seal can become more and more critical to these people in order to apply for status, for your clients to apply for status, because even if there is technically a waiver available, because the policies of the administration have changed from past administrations, those waivers are becoming more and more difficult to get. So by and large, we're talking about convictions. So a conviction in the immigration context is defined in the Immigration and Nationality Act as a formal judgment of guilt entered by a court. Sorry, I'm having technical difficulties here. Entered by a court. And there's a secondary portion of that definition having to do where someone has been given deferred adjudication or been able to do some type of pretrial intervention or diversion program, something of that nature. But the primary issue then is formal judgment of guilt entered by a court. And the agency and courts around the country have recognized that that definition does not address the effect of a state vacatur, where the underlying conviction or judgment has been vacated and the person's conviction is either dismissed or sealed. That's not addressed by that definition in the Immigration and Nationality Act. So the agency has come up with its own definition, or kind of explained the effect of the vacatur. There's a seminal case from 2003 called Pickering, where the agency recognized that vacatures that are premised on what's called a procedural or substantive defect are given effect in the immigration context, either for purposes of determining inadmissibility or removability, or for applying for applications for benefits. But they're not recognized when the vacatur is solely based on post-conviction events, such as rehabilitation or immigration hardships. So vacatures used to be recognized in many more contexts, including expungement, until 1997, and that's when this definition of conviction was actually added to the Immigration and Nationality Act. And Congress's intent in adding that was to both make a national standard, but also to really bear down hard on states that offered rehabilitative kind of statutes and create kind of a mechanism where the federal agency could still consider those as convictions, even if the state recognized that the person had been rehabilitated, that the agency wasn't going to follow suit and give that any weight or effect in the immigration matter. So initially, the agency recognized first that anything that was based on rehabilitation or immigration hardship was not going to be recognized. Then they added to that and a little bit later that this substantive or procedural defect being a exception to the general premise that a vacatur is not given effect. And all of the federal circuits in the country, with the exception of the Fifth, have accepted this formulation of conviction and this effect of vacatures on the definition of conviction. And just recently in April, the agency actually stepped in and overrode, for lack of a better word, the Fifth Circuit's interpretation as well to create a uniform standard. So now nationwide the standard is this one of procedural or substantive defects, vacatures are given effect, are recognized by the agency, but vacatures that are based on immigration hardship or rehabilitation are not recognized. So what is the definition then of a procedural or substantive defect? So there's a couple cases on this, but on the legal merits is kind of the main issue. If there's any type of violation of a constitutional right or procedural right that the state criminal code provides that wasn't honored or recognized, and that vacatur is premised on that violation, that is going to be a procedural or substantive defect. Some examples, ineffective assistance of counsel in the criminal case is recognized as being because that violates the Sixth Amendment, so that is a substantive defect in the proceeding. So if the underlying vacatur court recognizes that the criminal defense counsel provided ineffective assistance and vacates the conviction as a result, that's going to be recognized. Likewise, if there are, like I said, procedural protections in place under criminal procedural law for the state that are not followed, and the vacatur is premised on that, those are also going to be recognized as being not based on rehabilitation or immigration hardship, but instead on a procedural defect. So the case there that the agency is kind of the seminal case involves an Ohio statute that required courts to advise non-citizen defendants of the possibility of immigration removal, inadmissibility, or denial of naturalization. And if the court failed to do that, the conviction was vacated. So the agency said that a vacatur under that statute is for a procedural defect in the proceeding and is honored by the agency. Comparatively, a rehabilitative statute, this is kind of a little trickier, but any type of statute that talks about deferral or vacatur or expungement that's based on something that happens after the conviction, so successfully completing probation or a program or other conditions set by the court, or that set to restore rights that were taken away by the conviction, those are going to be rehabilitative statutes not recognized by the agency for purposes of whether it's a conviction still. For immigration hardships, this is kind of more along the lines of what the actual vacatur motion itself looks like, where or the court order for that matter, if there's any overt discussion and reference purely to immigration hardships. And this happened quite a bit before the people understood the standards or were aware, and this had been litigated, but back in the early 2000s, the mid-2000s, there were a lot of orders that were done because of the draconian, harsh, disproportionate consequences that were ushered in by the 1997 immigration laws. And so courts, unfortunately, in the agency recognized or failed to recognize those vacatures and said that those people still were convicted despite the state saying they were no longer convicted. So how do you prove then, because the substantive vacatur is a critical issue, so how do you actually prove that it's a substantive or procedural vacatur? the agency, it basically, through several different cases, has kind of come to this kind of framework of looking at three things in order. So first, the agency will look at the actual statute that the vacatur order was issued under. So what is the state law that allows for vacatur? So in the context of trafficking victims, you know, the ABA website has a listing of all the different state vacatur statutes, so you can go find your state and take a look at that. That's the actual substantive basis, potentially, for your vacatur. Next, the agency will look at the actual order signed by the court. So if the court provides any reasons or reasoning as to why it vacated the conviction beyond just the statute, that could potentially come in. And then lastly, and this has tripped up some people, if those prior two things aren't clear, then the agency also thinks, and some courts have agreed, that it can look at the underlying motion filed by the defendant for the vacatur to see what were the reasons in that paperwork. So, you know, why did what legal basis did the defendant claim for vacatur, and to see whether what the real basis was. So first, we'll talk about the kind of the statute providing a basis for vacatur. Kate mentioned earlier that New York was the first to enact a trafficking victim vacatur statute. That falls under the general vacatur statute in New York criminal procedure law, where it lists a whole slew of substantive or procedural defects and includes in that list this trafficking victim basis. You know, that case there, the matter of Rodriguez-Ruiz case from the BIA, that decision was recognizing that a violation of a constitutional right, as recognized as the basis of the vacatur, that was clearly a procedural defect, and the agency would recognize that vacatur. Next is what I mentioned earlier, this Ohio statute that requires courts to advise of possible consequences. The statute says that the judgment shall be set aside if the court does not advise. And so the agency, the BIA, said in the matter of Adamiak that that was clearly a procedural defect that would be recognized by the agency. And then lastly, the Pickering case I mentioned earlier. In that case, it was a Canadian statute, and while the board in Pickering did not agree that it was a substantive or procedural reason, it was reversed. The board was reversed by the Sixth Circuit afterwards, who actually analyzed the statute properly and said that you know, this was in fact a substantive or procedural defect, that the violation of the person's rights was the basis, and so it was recognized. So just to give you some quick examples that are listed here, so you know, rehabilitative statutes, in contrast, I mentioned earlier completing probation, for example, that statute would not be a procedural or substantive defect. Another case out of the Ninth Circuit involving after completing a sentence and going a certain amount of time without being rearrested, allowed for vacatur, or that would also not be recognized because it was solely related to post-conviction acts. And specifically in this context of people who are trafficking victims, Florida, for example, has a statute where not only do they look at whether the offense was committed as part of a human trafficking scheme, right? So that looks at the time of the offense. It also is even explicit about that, and presumably with an eye towards this matter of Pickering standard, that a conviction expunged under this Florida statute is a substantive defect. So that helps, right? So the agency looking and see how the state itself classifies what the vacatur was based on. And I'll talk about that a little more in depth later on, but that is the critical inquiry. That, you know, that is, if you have that in your order, so if you are vacating under Florida, that's a very good first step in making sure that the agency recognizes that. Next, we talked about the terms of the order itself. So if there are reasons given in the order by the court, the agency, because of full faith and credit, will recognize the reasoning given by the court. and will not investigate any further whether there were some hidden motivations by the court or by the prosecutor in vacating the conviction. That Matter of Rodriguez-Huey's case from before, the board was very specific that the agency was not authorized to go behind the state court judgment to verify whether it was properly done or what the motivations were behind that vacatur. And there's even a presumption recognized by the agency that state courts are assumed to not have acted contrary to a statute. So if the statute doesn't allow for a vacatur but for a substantive or procedural reason, then the agency should follow suit and say that that was what the actual reason was for the vacatur. And lastly, I mentioned the basis in the motion itself could be an issue. So in cases where the statute is not clear, so or if it's a common law vacatur, for example, like a quorum nobis, something like that, and the court order is also not clear what the underlying basis was, the agency and courts then have looked at what was the reason given by the non-citizen defendant in actually requesting the vacatur, and relying on that to determine what the reasoning was for the vacatur. And this is, in all those cases, as you can imagine, it came back to the detriment of the non-citizen because the reason given was explicitly having to do with immigration consequences. So in all those cases, Pickering, Pinho, Alim, Sullivan, Gonzalez, Ali V. Ashcroft, you see those there. The reasoning given was immigration consequences, and so in all those cases, the agency and the courts then said that this vacatur is not valid. The person still is convicted under immigration law, despite the state court setting aside and vacating the conviction. And I just want to kind of a practice point here. You make sure that you're distinguishing between the statute and the court order versus the vacatur motion. The BIA should not impart into the actual court order the petitioner's motivation for seeking to have the vacatur entered. I mean, any non-citizen who's seeking vacatur who has immigration issues, is a good bet that as part of that process or part of that reasoning is immigration related. But the critical inquiry is on the statute and the court order, and only if those are unclear, then you'll be looking at what the actual vacatur motion itself provides as the reasoning. And in the context of these trafficking victim statutes, that can become critical, right? So, are vacatures related to human trafficking, substantive rehabilitative? And as an initial matter, you have to consider the burden of proof. So in immigration proceedings, and the burden of proof can shift between the government and the non-citizen as to what the posture of the actual immigration issue is. So if the government is actually seeking removal, then the government could bear the burden, as opposed to if the non-citizen is seeking a benefit. So as mentioned earlier with Natalie's presentation in terms of the A visa or T visas or U visas, those are a benefit, and in those circumstances, the non-citizen have the burden. So because the majority probably of people seeking these vacatures who have immigration issues are going to be applying for some sort of benefit, the burden, you should never assume that the burden is going to be on the government and you don't have to document or be concerned with whether your statute is substantive or rehabilitative. You should always try to push it into the camp of being substantive, and I'll talk about that in a second. I guess now we need to take a short break because of a code that you need to see.
Yes, thank you, Ryan. Thank you for reminding me. We're going to pause shortly and display the participant verification code, which is required to receive CLE credit for this program. You will be asked to enter this code in the online attendance following the program, so we strongly encourage you to write down the code. The ABA participation verification code is 742580 742-580-90. That code again is 742-580-90. We'll leave this slide up for another couple of seconds so you can write down the participation verification code for CLE credit, and then we'll return to the PowerPoint. And Ryan, if I can, since I have this code up and I'm supposed to be talking during it, it's actually, as a non-immigration practitioner, but one of the attorneys that sort of set out to shape the practice of vacatur here in New York, it's really interesting to think about how we've evolved on thinking about the contents of the motion itself as it pertains to non-citizens, and this is largely through conversations we've had with immigration experts like yourself. Because initially the thought was in doing this work to vacate criminal convictions for survivors that we should be telling as complete a story as possible. And for many of our clients, our non-citizen clients, the fact of the potential immigration risks to them, right, of their criminal histories was a critical part of that, of their narrative and how they viewed themselves and their situation. And Bonnie, if you could put the PowerPoint back on, that would be fantastic. Thank you. But then in thinking about potential later analysis, right, and later interpretation of not only the vacatur statutes and the orders, but actually the motions themselves, led us to really have to think about what we were presenting in our motions of concerns about how it might be interpreted later on. So as a practice point for a non-immigration practitioner, this was a very pivotal point for us in developing our vacatur practice here in New York. We can talk later on if we have time about how to sort of, for states that don't have laws on the books yet, vacatur laws, what considerations are important, or states that are amending their laws to better line up with the experience of survivors. But certainly one of the things that practitioners should also be thinking about is the actual contents of the motion. So thank you for raising that for us, and I'll let you continue now that the code is done.
Sure. So under that standard, I mean, these trafficking vacatures are tricky, and it's not just because we don't have a lot of case law on this, which would certainly help. As far as I can tell, and I took a quick look last week just to confirm, no circuit has really addressed the effect of a trafficking victim vacatur in the context of immigration, as far as I can see, and the BIA also has not. So, you know, that could just be because the agency, you know, the DHS, the government agency responsible for removal, is not making an issue out of it yet, or, you know, thinking to try to deport people who are trafficking victims. But, you know, that could and might change. So it's always best to get ahead of the curve and be prepared for what may be coming down the road. So for, you know, the factors in terms of these trafficking victim specific vacatures, right, the procedural or substantive defect that would be relevant here has to do with, I think almost all, if not all, of these statutes require evidence that the person participated or was a trafficking victim at the time of the offense, right? So that's not related to post-conviction behavior or completion of probation or anything of that nature. It has to do solely, you know, it goes back in time to what was the situation at the time of the plea, and saying that the underlying plea was invalid. And none of the statutes recognize this explicitly, I don't believe, but right, if someone is a trafficking victim, that would be akin then to, you know, not having the requisite mens rea or a capacity to commit the offense, that they committed this offense only under duress, right? And so, you know, kind of what these statutes are recognizing is that wasn't a defense that should have or could have been raised at the time, but because of how courts viewed these, previously had viewed these types of convictions, that wasn't as much of a factor. But thankfully, legislatures are recognizing more and more that this actually should have been an issue at the time, and are not taking corrective action to fix what never should have happened in the first place. Conversely, though, right, a lot of the statutes do require the person to show that since the time of the conviction that they either have not been arrested or are no longer a trafficking victim. So, and unfortunately, a lot of the legislative history also going with a lot of these talks about restoring rights and ameliorating hardship, and that these are sympathetic defendants who, again, because they were under duress, really should not have the stigma of a conviction attached to them. And that falls more clearly under the rehabilitative prong. So, anything you can do when you're presenting these motions and when you're having your court order drafted in consultation with the prosecutor or with the judge, anything that you can do to emphasize the issues that were in place at the time of the plea relating to the substantive faults in the conviction, and minimizing potentially the immigration hardships, and that the person has been rehabilitated, right? I mean, rehabilitation in that context doesn't even really make a whole lot of sense if they were a trafficking victim, right? There was no rehabilitation. They were a victim previously, now they're not. They didn't need to rehabilitate anything. But just confirming that and making sure that that's clear, as Kate said, in your motion, and also, if you can, in the order from the court, that can help you if the burden of proof issue is present, where you're applying for a benefit, and you need to establish affirmatively that it was a substantive or procedural vacatur. And as we'll talk about later, this should all be done in consultation with an immigration attorney. And when they're presenting the benefits application or the motion to reopen to the court or the relief application, if it is the non-citizen's burden, or even if it's not, if you have good evidence of a procedural substantive defect vacatur because of the way the court worded its order or because of what you included in the motion, that attorney can attach that right along there, right, to make sure that there's no issues with the agency claiming that this was actually just rehabilitative and it had nothing to do with an underlying defect in the proceeding. Now, that being said, that all goes to, as I mentioned before, this definition of conviction in the Immigration Nationality Act. That is not the full picture. So there are other immigration statutes that are conduct-based, not conviction-based. And just to give you some examples there is a drug trafficker issue having to do with conduct, whether the agency has a reason to believe. So, even if the conviction has been vacated, that would not prevent the agency from making a finding that it has a reason to believe the person trafficked in drugs. And similarly, the general inadmissibility statute for convictions involving moral turpitude or controlled substance offenses includes convictions, but it also includes someone who commits or has admitted committing the essential elements of an offense. And there are a lot of procedural issues with that that the agency has to go through, but nevertheless, there could be an issue if your client admitted guilt in court under oath, and the vacatur is not considered, if there's an issue with whether there was a substantive or procedural vacatur, whether the plea was knowing and voluntary, those type of related issue concerns, the agency may try to bring that in as well. And if your trafficking vacatur, for example, goes to a drug trafficking crime, that it's not to say that it wouldn't be useful, right? So the agency has to still make findings, still has to decide to pursue it. If there really is a vacatur of a conviction involving drugs because of the person's forced participation as a trafficking victim as part of that scheme, that certainly seems to go to whether the person knowingly was a drug trafficker. The same duress defense could come in there. So it's not to say that you should not be pursuing vacatures under these statutes, but it's just to be aware that it's not the full picture in terms of applying for relief. And so just some takeaways. You should always include in your motion a substantive or legal basis for your vacatur. And where you have any say in the matter, trying to get the court to rely on that in its order can only help your client. And if you have serious questions, or if the state of the law in the future is changing on how courts have interpreted or how courts will interpret these statutes, you can always bring a vacatur under your state's general vacatur grounds, right? You can always file in the alternative. You could file a motion to withdraw the plea potentially under your state law. So it's never an and/or, right? You can always try both, and if the court and prosecutor agree that it really is a trafficking victim issue, but there's a concern with whether your state statute is clearly in the camp of being a substantive or procedural defect basis, you can always look at other grounds that are more clearly in that camp, such as ineffective assistance by the attorney for not investigating this duress issue. There were indications that the person was a victim of trafficking that were not investigated, or you can brainstorm. I mean, there are other ways that you could do it to more clearly fall in that. And again, this could be critical depending on the posture of the case in your circuit because of the burden of proof, where you will have your client is going to have to submit this paperwork to immigration, right? So it's important to think about the end game right from the start of pursuing this, even if timing-wise it's not going to be for a while. It's still important to litigate with an eye towards that as the ultimate issue you're going to have to prove. Because if the vacatur is not recognized and conviction is the issue, then it's for naught, right? So you want to make sure that it's all done to the best with an eye towards this substantive or procedural defect. With the final takeaway, right, you should always be consulting with an immigration expert to prepare the application and make sure that when it's needed to be submitted, that everything that the attorney needs is there to prove to the agency that it was a procedural or substantive defect.
Thank you so much, Ryan. I think with our remaining time, what I'm going to do is encourage the participants that have questions, if any, to go ahead and post those in the Q&A box that we can start to address participant questions. But as we're doing that, I'd like to talk just a little bit about the Survivor Reentry Project itself and what we do and how we can be a resource for attorneys and other advocates attending the webinar, and then think about some wrap-up questions that occurred to me as I was listening to both Ryan and Natalie today. The Survivor Reentry Project is a training and technical assistance project through the American Bar Association's Commission on Domestic and Sexual Violence. We offer resources and training around all issues connecting to criminal records of trafficking survivors. So this is vacatur, it is expungement, it is sealing, it is thinking through for states that don't have any relief available to survivors what a model law looks like, what the essential components of that law would be. For practitioners who are working on actual vacatur cases across the country, we offer ongoing assistance. We have a database full of materials that might be helpful. And then what we also have is we work as a clearinghouse for survivors themselves. And so because survivors end up all over the country, and because people who have had criminal legal system involvement often don't know what exactly appears on their criminal records, what the disposition or outcome of their criminal cases was, and how that might impact their eligibility for housing, employment, in the immigration context, all the ways in which criminal histories can have impact. We work with survivors who reach out to us to help them through the fingerprinting process, obtain their full criminal histories, analyze their criminal histories for any potential relief, whether it's under vacatur or expungement statutes specific to trafficking victims, or whether those general expungement schemes that Ryan alluded to at the end of his presentation also might offer additional forms of relief, other post-conviction advocacy that could benefit the survivors. We then try to match survivors up with a trained network of attorneys and other advocates across the country. So for example, when survivors come to us and they have complicated criminal histories that might span multiple states, which seems pretty daunting and overwhelming to the survivor themselves, we try to streamline the process. We attempt to put teams together so that we can avoid duplicating efforts, and so that the survivor themselves doesn't have to get bounced around between numerous attorneys in different parts of the country. And I see that we have a question about the vacatur concerns themselves, whether vacatur concerns apply for a specific immigration agency process or for all agencies and processes. The vacatur itself is not specific for an immigration agency or process. The vacatur is a process in the criminal court that goes back and revisits the criminal conviction itself. What we're dealing with here, though, is what the impact of that action in criminal court, that vacating a criminal conviction would have then in a subsequent immigration proceeding. So the vacatur itself, or expungement for trafficking survivors, is a process that occurs in the criminal court where the person was initially prosecuted. It is a post-conviction motion. And this is also complicated, again, by the fact that so many different state laws here use different language, different terms and vocabulary to describe criminal record relief for survivors. And it's also further complicated by the fact that criminal procedure law in each state looks so different, both process and law. So for example, one of the things that we deal with all the time outside of the immigration context is that for many people, vacatur really deals with a criminal conviction, a finding of guilt, as Ryan specified. But for many people in many states, the court outcome or disposition is one thing, but arrest records survive the court process regardless of the outcome in court. So in most states in the country, even if you get your case dismissed, so if you're convicted of a crime and then you come back in and successfully vacate it and get it dismissed, or if you were never convicted of anything to begin with, if your case was simply dismissed after prosecution at the beginning, the arrest records remain. And while this is not necessarily an issue for non-citizens specifically, these records tend to follow people around as well. So the process of vacating, expunging, sealing is really dealing with the court disposition or outcome of the criminal court prosecution, as well as maybe any arrest records that might attach or have been related to the initial arrest that was the subject of the court proceeding. I'm thinking, going back to Natalie's presentation, and Natalie, if I can put you on the spot a little, one of the things that I think there may be a little bit of misunderstanding about with respect to the T visa is that being in the U.S. on account of trafficking. Can you talk a little bit about how that plays out, how that's interpreted, and what practitioners kind of need to know to assess eligibility on that ground?
Yeah, I mean, it's sort of a strange requirement, right? But I think without seeing as we only have a few minutes left and I don't want to get too far into the weeds on it, essentially it's really not something that you should be concerned about or something that should prevent you from sending somebody to an immigration lawyer to see if a client's going to be eligible for the T visa, right? So essentially the way that that's been interpreted is even if somebody had been here in the United States for years even prior to them being trafficked here in the United States, that person is still going to be T visa eligible, right? So I don't want to get too bogged down into the legal framework of exactly how, what, or why that happens, but essentially if they are here in the United States and they were trafficked, they're almost certainly going to be eligible. So I wouldn't worry too much about saying, well, I guess what maybe the most important takeaway is that you don't have to demonstrate that that person was brought to the United States by the trafficker that ultimately trafficked them and makes them eligible for the T visa.
Thank you. No, I think that's an important point and one that I just wanted to make sure that people weren't getting sort of stuck on that point and then not proceeding to maybe some of the other potential grounds of eligibility.
Yeah, that's a great clarification.
So Ryan, we have a question also about, you've really laid out the difference between, substantive versus rehabilitative in terms of interpreting the grounds for vacating a conviction. And the question that we have is, does this apply in all immigration analysis, or is this specific to trafficking victims or those seeking affirmative relief as victims of trafficking?
It's a really good question. It does apply basically to all because it has to do with the Immigration Nationalities Act's definition of conviction. So the agency will apply that anywhere where that is raised. So when applying for seeking a T visa or U visa, then the issue is under the INA Section 212A2A11, convicted of a crime of moral turpitude or a crime related to a controlled substance as defined in the Federal Act. If your person is in removal proceedings, then it is a different section having to do with they're convicted of a crime of moral turpitude within 5 years or with 2 or more crimes. So it's the same language and the same issue is raised in all those contexts of whether the person is convicted, because they all rely on the same definition of conviction at that 101A48A.
Great, thank you. And it sounds like we also have some inquiries about maybe more, I don't even want to say more complicated trafficking situations, but situations where a trafficking victim's criminal history maybe doesn't line up exactly with the state vacatur relief, and so a person may be left with convictions on their record that need to be dealt with in the immigration context, but may have some connection to trafficking, but might not be eligible to be vacated. So for example, a conviction that a person incurred while they were continuing to engage in illegal activity because they were facing instability after escaping a trafficker, where they might not be eligible for vacatur relief, but there is that sort of nexus because it's a result of having been trafficked and the resulting instability in their lives. Or, for example, someone who has a conviction for a non-prostitution offense in a state where vacatur relief for trafficking victims is limited to only prostitution offenses. And what I would say about these scenarios, these sort of difficult scenarios that place people outside of maybe the vacatur framework or just slightly outside, and with a little creativity we can maybe push inside, but then there's resulting immigration analysis that we must do. I'm going to encourage practitioners to get in touch with the Survivor Reentry Project to talk through specific cases and think about creative ways to approach these complicated, interconnected issues. So I encourage all inquiries for survivor reentry. Our website has both that comprehensive list of state vacatur statutes for trafficking victims that Ryan mentioned earlier. So again, if you realize that your client has a criminal conviction in a particular state, hop on our website, check out what relief might be available to them, reach out to us to see if there are practitioners in that state or jurisdiction that are working on criminal record advocacy for survivors. We can connect accordingly. But I think one question I want to come back to is, and I'm not sure that there is an answer to this. So indulge me in asking, and then there might not actually be an answer, but something that we should maybe have on our radar screens is because of the particular climate that we're in right now. I mean, Natalie mentioned at the very beginning that immigrants are, we know, historically uniquely vulnerable to being victimized, but also uniquely fearful of law enforcement interaction. And in this particular moment, those concerns and fear are certainly heightened. And rightfully so. So thinking about people who are already in removal proceedings, who are in a more defensive posture, whose criminal histories are being used as a grounds for removal, how can we as advocate communities think about accelerating or expediting vacatur relief where the person in removal proceedings has been a victim of trafficking? What are some things we could be doing collectively to make sure that those that are in most danger right now, that are victims of trafficking, get connected to relief, but also recognizing that as we've built the vacatur process across the country, and it's brand new, and sort of this legal grounds of relief is new, how do we expedite the process for, in order to get relief to the people where the outcome of immigration proceedings might hinge on that, where otherwise the vacatur process has been really slow to develop. Do Ryan, you or Natalie have any thoughts on sort of triage in this way? A long-winded question.
This is Ryan. I mean, when someone is in removal, it's difficult because there's no right to counsel in connection with the removal case, right? But if they have access to counsel, and a lot of these vacatur statutes seem to contemplate prosecutorial involvement. Mm-hmm. So in lieu of filing a full and complete motion, it may be possible to reach out to the prosecutor's office on a more informal basis just to raise the issue. And this is, again, this is a very a new area, but reach out to them informally before having to go through the full requirements of completing a full motion just to get the position, because if you can get consent from the prosecutor, that could streamline the process, would be one thing I would think of that you could do to speed it up.
It seems to me that we need to be making sure that our criminal record advocacy, our sort of reentry community folks that are really well-versed in doing expungement, sealing, vacatur work, post-conviction work, are also connecting and communicating with our immigration advocates to make sure that we are finding those opportunities for expedited advocacy where possible, and making sure that the relief is getting to those that are, again, at heightened risk and need more immediate relief. Seeing no further questions from our participants, I would like to thank everyone for joining us today for this webinar. We really do want to encourage you to use the Survivor Reentry Project as a resource, whether you are an experienced immigration attorney, whether you're an experienced post-conviction advocate, whether this is your first time entering into this field at all. We're here to support you and are happy to share resources, to talk through cases, and to recruit you as part of our network of legal services, defender advocates, and pro bono attorneys that are working on these issues to make sure that survivors have good, comprehensive legal representation. Visit our website to see the materials that we have available for you and how we can work with you. And thank you all so much for joining us today.
Thank you so much, Kate, and thank you to all of our presenters, Kate Mogulescu, Ryan Muennich, and Natalie Nanasi, for sharing your time and expertise on how to best work with and support immigrant survivors of trafficking in post-conviction cases. On behalf of the ABA Commission on Domestic and Sexual Violence, thank you all for joining us today. Before leaving, please wait for the evaluation and CLE information to come up on your screen. I will turn you over now to our operator for some additional information.
Thank you. As mentioned before, if you have any additional questions, please submit a technical assistance request form on the Survivor Reentry Project website, ambar.org/SRP. For those of you who want CLE credit, please click on the link now appearing in the presentation window. This will open the program evaluation. After you submit the evaluation, the attendance confirmation form and request for CLE credit will appear. Please complete the information requested on the form and submit. Your information will be verified, and if your attendance meets all the requirements for CLE credit, your certificate will be emailed to you. On behalf of the ABA Commission on Domestic and Sexual Violence and the ABA Center for Professional Development, thank you for participating in this program.